research, and as part of that research I met Kevin, and he agreed to come up here at his own expense to talk to the public, and he has a presentation that he's given all over the state, and probably, has this been given in other states too? Yeah. So he's a wealth of knowledge, and he'd like to share some of that knowledge with us today. He belongs to the Interstate Informed Citizens Coalition, and he's a former planning commissioner from Baraga Township, which is down by Ohio, and that's when he started learning about wind energy. And so I'm going to just hand it over to him because he's a better speaker than I am. But thank you so much for coming. Really appreciate it.
Well, thanks, Catherine. It's a privilege to be here, and I'll try and stay out of the screen. And I didn't set this up like this for me. I'm not a big balloon guy. So yeah, I'm the director of the IICC. What is that? Well, it's not some dark fossil fuel funded anti-renewable energy corporation. It's a group of folks from our township, very much like this one, who was founded when a wind project was proposed in our community. And we incorporated because we were afraid that Consumers Energy and Exelon might sue us, and we didn't want to lose our houses. Turns out it was not a profound fear, but that is how this happened. And after we got done with our round of wind energy zoning in 2011, folks started calling and asking us if we could come and talk to them about our experience. Here I am now. So the other credential is that I'm a senior policy fellow with the E&E Legal Institute in Washington, D.C. Again, that's a volunteer position. They like some of my writing on energy policy. I receive no funding from them at all. So I drove up with my skis in the back of my car, hoping I can at least do some skiing before I go home. I actually have a long history with wind energy development in the Upper Peninsula. Believe it or not, that's near Crystal Falls. My grandfather and great-grandfather are in that picture as far as I know. That was a windmill that was built, and this was pictures in 1923. My great-grandfather is buried in an unmarked grave in Crystal Falls, and my grandparents on my father's side are both buried in Mackinac County. I still have cousins in the Trout Lake, Rexton area. But his crazy friend from Lithuania built this windmill. Apparently the millstones still exist in Crystal Falls at Alex Bordolini's place. For better or worse, that's my history. My grandfather and his brother were both taken out of the home when they were young and placed in the Goodwill farm back then for neglect. And so here's kind of a map of my UP roots. Let me see. Oh, and some of you, I don't know if any of you know Oscar Johnson from, he was my grandmother's last husband. After my grandfather died, she was married to Oscar for a few years. So I even have some roots here in Lawrence. So, despite all this talk about my UP roots, I know what folks up here think because my grandfather told me this a lot. He said, you're just a beet lifter. That's what he called us from down below, sugar beet. He said, you guys come up here every fall for 2 weeks with nothing but a $20 bill and a pair of bib overalls, and you don't change either one. And so he would never let me consider myself a real Youper. So what about my credentials? Well, I got a degree from the University of Michigan, but so does a Unabomber. I got my start in land use policy in Baraga Township. We worked on ag land preservation, and one of the things I'm most proud of is that the ordinance we created was added to a list of model wind energy ordinances that the state of Michigan used to maintain. And that's ours down at the bottom. If you're curious about our wind energy ordinance, you can find it at rigatownship.com, R-I-G-A township.com, under wind energy zoning. A few more pieces of boilerplate. I am not a lawyer, but I do watch Law and Order. I'm not offering you legal advice, and this is an important one. Dealing with wind energy zoning ordinances, which is one of the things that will become part of our discussion tonight, is very specialized. And there are a lot of very good local municipal attorneys, but we found out that a lot of local municipal attorneys in rural communities don't really deal with many profound or complicated land use issues. And so we have several attorneys that we've worked with across the state that we recommend. And if you feel, or your local attorney feels uncomfortable helping you with this, we can certainly connect you with some good folks. But it is a specialty. And again, more boilerplate. There are hit pieces that get circulated about me occasionally that say I'm a fossil fuel funded hatchet man for the anti-wind movement. I know what my ties to the fossil fuel industry are that I'm a remodeling contractor, which means we install a lot of shingles, and shingles are filled with asphalt. That's my tie to the fossil fuel industry. I don't have any ties to these deep, dark forces. I'm not a paid lobbyist, and I donate my time. So for what that's worth, it's a shame that I even have to say it. I'm here to talk about land use issues. I will say this is a different kind of land use talk than I've ever had before, because up till this project was proposed, essentially all wind development in the state has been proposed in agricultural ground, mixed use ag residential, like in the thumb down in Lenawee County, Gratiot County in the middle of the state. This is the first project in Michigan that's proposed in what's essentially a wilderness area. Some of these have been proposed and built in Vermont, Maine, Quebec, and so forth. So this is a little different, so I've had to adjust my talk. But yet there are some agricultural areas in the Upper Peninsula that will want to consider some of these regulations as well. So I didn't take the ag residential mixed use kind of suggestions out of the presentation, I simply added to it. This is kind of a complicated slide, but sometimes you'll run into this, that a wind developer will say, well, yes, I see all these concerns about various types of turbines and various kinds of issues that could be associated with it, and I see that you're concerned about these types of setbacks and they only go in this regions, but we're going to build this particular type of turbine and we're going to put it only in this particular area so you don't have to worry about all these other things in your ordinance. And I would just say, don't fall into the trap of believing that you're developing a wind energy zoning ordinance for just a developer, a particular developer, because a wind energy zoning ordinance will apply to any developer that comes now or into the future. So though a developer may intend to follow certain claims they make, they don't speak for all the present and future guys who may also be coming to your community that you haven't yet discovered. So realize your zoning ordinance is for all comers. You're not negotiating an ordinance with just a particular developer. The following slides are what's proposed. These came from an RES project. I found them on the internet. They're available freely in the public domain. They're calling it the Summit Lake Wind Project. This is their stuff. RES is a UK company with a US subsidiary, RES Americas. Michigan's, the experience that RES has been in the thumb. 2 projects were approved and have been constructed there. Both were sold. RES doesn't own either one of them. One, I think, belongs to Algonquin, and the other was sold to NextEra, and then I think to Detroit Edison. So RES primarily gets the project approval and will then seek to find other people to take the project over, either post-construction or pre-construction. Apex and Geronimo are 2 other companies in the state that do that. So again, the folks that may be negotiating with you at a bargaining table are likely not going to be the folks you're dealing with in an enforcement situation of your ordinance 2 or 3 years down the road. That's important to keep in mind. And here's their project footprint. Here's the area involved right now. I think it's all in Lotz Township at this point. And we dug up the FAA. They have to go to the FAA for approval for tall structures. And so I don't believe all these locations are in their present proposal right now, but those have been, those locations were put before the FAA for approval. And that's where the data from this map came from. If there's any errors, we apologize. The yellow line, we believe, is where the transmission lines are supposed to be routed. This is an important thing. The wind industry and their advocates want to make this discussion of wind energy development for your community a question about revenue for your community, about how great green energy is, how noble it is, how wonderful it is for the environment, etc. But as a zoning official, you need to remember, your only concern is how to safely and appropriately site 50, 60, and now even 70-story tall noisy structures into your community in a way that doesn't conflict with neighboring land uses. I don't care if those 50, 60, 70-story tall structures produce electricity, suck oil out of the ground, extract coal out of the ground, or turn sow's ears into silk purses. From a land use perspective, I don't care what those devices are doing. All I care about is that they're tall and they make noise, and how do we safely site them in our community. So a discussion about siting these tall, noisy structures in your community is not a referendum on whether or not you like renewable energy or clean energy. It's strictly a question about how you separate conflicting uses of land. And to you elected and appointed officials here, I know what it's like, because I've sat on your side of the table, when a developer comes and says, we want to do this in your community. And suddenly you're faced with a question of trying to divine in your head, what do all the people in my township really want? And that's not a question that any of us really thought we were going to have to answer for developments that include such a large number of really big structures that are totally out of character with the rest of your community. It's nothing that anybody expected, and a lot of times, I volunteer my time, but a lot of times our planning commission positions are not much more than volunteer wages either. I understand that. I think if you adopt some of the principles I talk about in here, you can take some of that pressure off. And then we'll talk about that a little bit as we move forward. All I should really be talking about is how to regulate these tall, noisy structures in your community. That's the main gist of the zoning issue. However, the wind companies will force us to talk about a lot of other ancillary issues associated with wind, like carbon emissions, cost of energy, tax revenue for your communities, etc. They want to make this a debate about those kinds of issues, when in truth we're just dealing with these tall, noisy structures. So I'd rather not talk about any of those attendant issues, except I have to, because the wind industry will talk about them almost exclusively. So I'm going to address some of their higher level macroeconomic claims about wind development that I think at least pays for you to hear another side to these issues. One of the things we've learned since our renewable energy mandate was adopted in 2008 is Michigan's wind energy is very expensive compared to wind energy from other states. If you look at a windy state like Iowa, you see those purple sections in the map there. Those are very high wind resources. If you look at the Michigan map, you'll see we don't really have any purple wind resources. It matters a lot, because the potential energy from a given turbine is equal to the cube of the wind speed. Long story short, every turbine that was built in the tip of the thumb, if it was built in Iowa, would produce roughly twice the amount of electricity by just putting it in a better wind resource. It would also reduce far more CO2 by building that capital-intensive structure in a better wind resource. This is borne out in the wind energy power purchase agreements that are recorded. The purple band is some of the most economical wind in the country. It's all out west. The red line I superimposed, taking our wind power purchase agreements from the MPSC's published reports. You'll see that some of our most expensive wind anywhere in the U.S. is from Michigan. And in fact, the Garden Peninsula project came in between $105 and $110 a megawatt hour, one of the most expensive wind contracts ever signed in the history of the United States, after receiving a 30% subsidy up front as part of the Section 1603 grants. It's either $105 or $110 a megawatt hour, but if you go to Google and search PA 295 annual report, you'll get every year's version and you can read the data yourself. The other thing the wind industry says is wind is cheap and getting cheaper, but that's changed. If you look at the red line, you'll see wind contracts did drop for a long time, but as wind was pushed out of the windier thumb and back into places in the center of the state like Gratiot County, you see Detroit Edison's latest project in Pine River is back to $60. That's the most expensive, according to this Wind Technologies report anyways, recorded in 2016 anywhere in the U.S. So the price of wind energy in Michigan is going up, and it's because wind is being pushed into lower wind regions. I would say that this Baraga Township project is in a similarly poor wind resource. Here's some of our contracts over time, $104 down to $50. But let's take a look at what's being offered into Missouri from the windy states. $18, $17, $21. 2 to 3 times the price we're paying for wind energy here versus the West. But under our latest energy law and the earlier one, the state has made it illegal for us to import far cheaper wind energy from out of state. It protects our in-state utilities. It allows them to continue to build uneconomical wind turbines because they get a regulated rate of profit. Detroit Edison, if they build as a regulated utility a 100 megawatt wind project, the ratepayers will help pay for that at the cost of about $220 million to build it. And they get guaranteed profits of $125 million over 20 years. And when the full production tax credit is in effect, they'll get another $80 million. So rather than fossil fuel like utilities like Detroit Edison opposing wind development, it's actually a tremendous profit center for them. Secondly, of course, we're concerned about the climate. That's one of the big concerns. If you're concerned about CO2 emissions, we calculate that with a number called the social cost of carbon. In other words, if we continue to emit CO2 like we are, what's the net cost to our society in monetary terms for continuing to let that CO2 be emitted unabated. And so all the social harms is valued by the Obama administration at $40 a ton per CO2 from tidal rise and all the other things that come. That's the total, all that's baked into that $40 price. Well, MISO that's our grid operator. They did a calculation on the Obama Clean Power Plan that had these various building blocks to help lead a path toward a lower carbon power sector. Block 3 was to add in X amount of wind generation to reduce CO2 emissions. You can see that MISO's calculation says that by adding wind into our generation mix, we will reduce CO2 emissions, but they will be at a price of $237 a ton. So we're going to pay $237 a ton for wind generation CO2 reductions for a harm that the Obama administration only values at $40. There's 6 times the economic harm to ratepayers by using wind to reduce CO2 than just eating the CO2 emissions. That's not my numbers. I didn't get those from Breitbart or some wacky anti-renewable site. This is from MISO and the Obama administration. So, if we take a look at the windy tip of the thumb down there and look at the wind resource up here in Baraga, remember, the thumb already is not very good wind compared to the western states, but if you look at Baraga, it's even worse. So why is wind here? Well, it's a good question. Let's go back and look at a little history. This is Huron County, Bad Axe is in the center there, and the tip of the thumb, arguably our best wind resource. The green stars show places where wind has currently been built. Right now, Huron County has roughly 500 turbines in operation in Huron County. That's more than any other county this side of the Mississippi that I'm aware of, except maybe Benton County, Indiana. 3 townships in red, which had township level zoning, had already adopted restrictive wind zoning that prevented wind turbines from being constructed there. But the others largely were under county zoning. One of the reasons wind developers had such success in Huron County is that a majority of their planning commission members in 2007, 8, and 9 had signed wind leases when they were creating their wind ordinance. In fact, out of the 25 townships that have operating wind developments in the state of Michigan, if you know of an example where we're wrong, please tell us. But we've found in every one of those townships there was at least one leaseholder somewhere in the Zoning Board of Appeals, the Planning Commission, or the Township or County Board. So where a conflict of interest goes, wind goes. So wind has been a free-for-all on the tip of the thumb, but it changed in 2016 drastically. 3 more Huron County townships, Sherman, Sand Beach, and Lincoln, and parts of surrounding ones, faced additional development by Detroit Edison and NextEra. And I remember RES did 2 projects there as well. And in Lincoln Township, remember I talked about the conflict of interest. Lincoln's up in the top left corner there. 4 out of 5 of those township trustees had Detroit Edison wind leases. Secondly, here at Lincoln Township is under Huron County zoning because Lincoln Township didn't have their own planning commission. So 4 out of 5 people on that board are in line to get the big wind checks, right? They're going to profit handsomely. Nonetheless, they could look out their windows and see what pervasive wind development had done to Huron County. They sent a letter as they were looking at extending a new wind district into their townships that said, we feel that Huron County has done our part as far as green energy. We feel that no additional turbines should be allowed in Huron County. 4 of the 5 were going to get the big checks. 4 of the 5 said, enough is enough. We've got enough. They in Sherman and Sand Beach townships took action to take control of their zoning or to amend their ordinances so that they couldn't be built. I don't want to make it a complicated story, but the bottom line is there were several county-wide and township-wide zoning referenda elections last May, a year ago May 2nd. The campaign got quite absurd. Detroit Edison has really built a lot of wind up there. They were desperate to get another project approved, so they actually sent the CEO of DT Electric to Huron County to campaign for the thing. He stayed there for a while. And their advertising said this, get this, Dear Huron County residents, we know that some of you may be concerned about the number of wind turbines in Huron County, and DT Energy is committed to addressing those concerns. I'd like to assure you that we will not ask for new wind development in the county. Voting yes on the county proposals just means completing the plan already approved by your local government. We hope you can count on your support. They basically said, please, just let us have one more and we promise we won't do this to you again. Which is kind of ironic because all they ever told us is it's a wonderful blessing and the people who are opposed to these things just are unfamiliar with what wind development really means and over time they'll get used to it. Not so fast. NextEra, DTE's business partner, one of the PACs affiliated with their campaign got really ugly. Why is this lawyer smiling? He says, vote no on May 2nd. Why? Vote no to protect Sand Beach Township from costly lawsuits. NextEra's PAC basically said, vote no on this ballot issue or we're going to sue you. Apparently that's a new definition of being a good neighbor that I'm not familiar with. And at the same time, NextEra was already involved in litigation with 2 townships in Tuscola County. They've lost round 1, and we fully expect the townships to win all counts of that case. The Huron County residents fought back, and I always get emotional about this part because it's pretty epic, but these are just folks like you guys. And they picketed, they protested, the sign at the top says it all, I can't read it or I'll cry like a 290-pound baby. But they fought hard, and I was very proud of them. Guess what? Campaign expenditures showed that DTE and NextEra spent $875,000 on that ballot campaign. The folks spent $3,700 bucks. They accused me of being involved with the opposition and said I was funded by the Koch brothers to help them fight this. Now, you know, DTE and NextEra are some of the biggest fossil fuel companies in the U.S., right? And if I had Koch brother money, I would have made sure that we'd spend at least $500,000. But I don't have Koch brother money. The folks spent $3,700. Here's how the vote came out. 64 to 36% in both elections. The people said no, enough is enough. Wind losing at the ballot box, despite lopsided campaign expenditures, is not rare in Michigan. Right now, about 40 townships have written regulations that prohibit any more wind development. Multiple counties have as well, including Schoolcraft County. It's becoming more and more common. 17 times wind through one form or another has been on a township ballot, and wind has lost 17 out of 17 times at the township level. In Argyle Township, where it was 53 to 47, Invenergy spent $164,000 in PR in one 36 square mile township. The people spent like $2,500. Invenergy's people were handing out hats and t-shirts at the intersection on election day. There were fistfights. The other thing that these votes show is the deep division pervasive wind development yields in your social fabric of your community, and it doesn't go away. I'm not here to tell you what to do in your township. You guys have the complete power to decide that, but I can tell you my experience around the state is wind generation divides communities in a pretty ugly way. When I drive through my rural farm community where I used to see Joe and Sally's house and Frank's house, I see in my head, he wanted them, he didn't. He wanted them, he didn't. That's no way to have a community, and that's the way it worked. You're different here because in most townships we'd have about 15 farmers in the back who would sign their own farm parcels up wearing wind hats saying we want this thing, but in this case it's my understanding that all the turbines are going on Weyerhaeuser lumber property. What that means at the ballot box is Weyerhaeuser doesn't get to vote in your township election. Only you guys do, which makes a difference. So, like I said, a lot of townships have rejected wind energy zoning. So why are they here? Despite successfully selling 2 wind projects in a much windier thumb, the folks there have essentially rejected all future wind development. So RES and other companies are now spreading all across the state into very low wind resource areas like Branch County, Lapeer County, Midland County, Bay County, and the price of wind energy, we believe, will continue to rise because of that. In my mind, they're looking for wind-naive communities that haven't been through what the people in the thumb have been. And they're hoping to find people that don't know the rights under the Michigan Zoning Enabling Act to regulate land use, including utility-scale wind development, in the way they see fit. So now let's talk about some of the financial claims, because typically a wind developer will start talking about tax revenue and lease payments to leaseholders, though that's harder here because you don't have any local leaseholders that are going to be buying new farm equipment and so forth because of this money, but maybe there's a way that it passes through, I don't know. But they use that as an inducement for permissive wind energy zoning. All the money that will come to you through a wind project is recovered from ratepayers somewhere, or from the U.S. Treasury. There is no free lunch. The money that's being used to somewhat fatten your township coffers, and by the way, wind generators don't pay school operating millages. They pay any debt retirement or sinking fund obligation you may have. But unlike your mom and pop hardware store, which contributes toward your school operating millages, Unless the tax law has changed since I've looked at it, they're not paying anything towards your operating millages, so be aware of that. But the bottom line is, all the money, because utilities take money from every household, unless you're Amish or off the grid, it's basically money extracted from other people and funneled into a few select people, few select townships, but the lion's share by far goes back to the company that owns and operates the turbines. There is no free lunch. It's summed up well in this little cartoon. The man says, look, he's giving us all money just like he promised, and she says, he has your wallet. So what about your very expensive utility bills here in the UP, right? We all are aware of that. Is this project going to save you money on your utility bill? Is it going to go up? Is it not going to stay the same? What I've heard from people who've been at some meetings with RES, they have said they're not sure. All I can say is my contacts in the regulatory regime in the state of Michigan feel, as I do, that wind generation, because it works in a parasite-host relationship with conventional generators, is not likely to reduce costs. And in fact, with new generators like the ones being constructed in the UP, they're likely to drive up the operating costs of those generators by reducing how often they run. So you're spreading the capital cost of building those generators across fewer units of sale. Can't prove that, but that's my strong hunch. This much I know. If the wind developer in your community felt strongly that they could make the case that your utility bills are going to go down with the approval of this project, that's all you would hear all day long, because that's a selling point. I don't see any way that you can come up with that argument. I'm not a grid technician. I'm not going to argue it in fine detail. And I just explained that, so I don't have to do it again. Worst case scenario would be if RES or whoever eventually buys it sells the energy to a corporate customer like Amazon or Facebook or somebody out of state, because the revenue is going to flow from Amazon or Facebook to RES or whoever buys the project, yet the energy is going to be generated here, displacing local generators during certain market conditions. So the only people getting direct benefit would be whoever owns the outfit and whoever's buying it at a retail rate, probably out of market, while at the same time it's displacing your local generators, which it's your best interest to have them run as often as possible, so you get maximum utility out of ratepayer dollars. That's worst case. So as I said before, all wind projects to date in Michigan have been located in mixed-use ag and residential properties. But here in the Summit Lake project, we have something different and unique for the state of Michigan. We have a lot of forestry land and seasonal human habitation. A lot of folks have camps there, cabins and so forth. I haven't been up there. It's hard to get up there and drive around. I've been far enough up on the Pashiki grade at 11 o'clock at night that my wife said, please turn around and go back, and so we did. And that was the end. There were a few bridges she couldn't see the other side of, and I said, okay. So we don't have the same type, maybe, or quantity of human impacts that we might have in a rural township with 2,000 or 3,000 people in it, or 1,000. But this project will bring a dramatic change to the natural environment and the human beings that share it with nature. That is beyond dispute. Fortunately, Michigan townships, and this is important, townships don't know this, and I didn't know this until I got into this issue as his planning commissioner. We are free to develop land use regulations that protect that environment in any reasonable way they see fit. I know some folks are concerned about the mine, and I know in the end the state really had the biggest share. And I also know in this room there are going to be some people that love the Eagle Mine and some who hate it. I get that. I'm not here to talk about mining. But the truth is the state played a large role in regulating that. Wind is not like that. Ultimate authority for regulating wind generation is in your township board. Those with local rule zoning have the ultimate authority to regulate land use. The wind companies can only beg you to change your ordinance. You do not have to. You are the ultimate land use authority in your township. So let's talk about the Michigan experience. I don't want to talk all night, though it seems like I often do. We have over 1,500 megawatts of wind installed and more being installed. So the state started out with ag land recommendations anyways of only 1,000-foot setbacks and 55 decibel noise limits. It wasn't a binding recommendation, but the wind developers that came in to see me laid those regulations down and said, this is what the state says is safe. We want it. Back then, of course, the turbines were only 390 feet tall. But experience has been a pretty harsh teacher. These stars, and I've not updated in a long time. But there has been widespread issues with wind development all across the state. It's not unique, it's not rare, it's pervasive. It's been an ugly track record, very divisive in communities. Something else we've learned about wind energy since 2008 is that wind energy is very land use intensive. That's one of the big negatives associated with land use in wind. Let's say you really hate nuclear power. Some folks in this room will, some folks will love it. I don't really care. I'm not an investor in any of these energy technologies. Let's say you don't like nuclear and you want to see the 1100 megawatt Fermi nuclear reactor go to Newport. Could you replace it with wind? Yes. You can put two 1.8 megawatt Vestas V100 turbines in every square mile from Toledo to Detroit to Ann Arbor. But because the wind doesn't blow in July and August, you're going to need about 1,100 megawatts worth of gas-fired generation for all those times that the wind isn't blowing. From another perspective, 36 square miles or one rural township of wind turbines like this. Sir, I will put this entire presentation on YouTube, and I will gladly email you all my slides if you don't want to feel like you got to take a picture of 112 slides. It was perfectly available to you, just to make it easier for you. 36 square miles of a rural township covered with turbines like this will produce roughly the same amount of electricity that can be produced from a semi-trailer mounted gas turbine that you can hide inside a dairy barn. It takes a lot of turbines to produce a relatively small amount of electricity. Very low energy density. That's just the physics of it. Another food for thought. Did you know that every gas, coal, and nuclear power plant in the state of Michigan would fit inside of just one rural township? Just one? All of them would fit in just one township. DTE has proposed 4,000 megawatts of wind, which is not much more annual potential than one nuclear power plant. It would require 50 or 60 townships covered with wind turbines. That's the problem with low-density energy sources. So, now, finally, we get to talk about wind energy and zoning issues directly. If we were here if I was trying to sell you a car, we were going to think, if you're a wise car buyer, you're going to say, what's my total cost of ownership? Or a snow machine, or a chainsaw, or a truck. You're all doing a certain amount of math in your head saying, I have only this much money, I have these transportation needs, what vehicles are going to work best for me? That works pretty well because we're all very familiar with things like cars. Pretty simple. But when a wind developer shows up and says, I'm going to build 50 or 100 Vestas V100 turbines, like they said in my township, we now have to ask ourselves some questions about what is typically, at least up here still, a pretty unfamiliar product. Down in the thumb, we all know what they are now. But your first question is, how tall is 494 feet? Well, it's difficult to get a sense of scale for that. But this may help. The towers at the Mackinac Bridge are 552 feet to the top from the water line. So 494-foot turbines would reach almost to the top. And the new ones that Apex is proposing in the middle of the state are 600-footers, and I'm hearing of 650 and 700s now. So remember when I said your zoning ordinance isn't designed to accommodate just one developer and one project? Because they might tell you, well, there's no sense putting a height limit in because we're only going to build 490-foot tall turbines. They're not the only developer. And somebody 2 years from now will be back with 600s, which we didn't think would ever happen in 2010, by the way. So that gives you an example. Here's a friend's of mine house in Ludington. That's the 476-foot V100 with a little smaller rotor. That's 1,193 feet from his house. The noise from that turbine was sufficient to put him and his wife in the basement to sleep at night with sleeping pills. They ultimately abandoned that home at about a 30% loss and moved 2 miles outside the turbine footprint and built a new house to get away from the noise. A number of people in that community sued. There was a settlement. The terms are not disclosed. But they warned the township and the county ahead of time that the noise regulations you're using are not going to be adequate to protect our health, safety, and welfare. In fact, they sued the county and lost, and the project was built anyways. So, is this guy some kind of crackpot? No. After all this settled out and the litigation ended, they actually appointed Mr. Schindeldecker to the Planning Commission in Mason County. And their zoning ordinance has been amended so that the 56 turbines that are operating in Mason County will be the end of it in Mason County. Consumers Energy could have built many more there, but the county said 56 is enough for us, no more. So, what would wind development look like here? Well, this is a development in Quebec. I picked it because the terrain strikes me as being somewhat similar to what you might see here. It's a rural environment. It's swampy. trees, you see a lot of roads, a lot of turbines. I can't tell you it'll be the same density. I don't know those things. I haven't seen a site plan for the turbines. But this is what it might look in your neck of the woods or something like this. The roads have to be ample enough to transport a crane that can reach up to 400 plus feet to be able to assemble the thing. It's not simple, it's not easy. Here's what the transmission may look like. This is in the Garden Peninsula. I need a number of miles of that to complete the project here. And, you know, University of Michigan did a study of how people's perceptions are of wind projects after they're built in the thumb. And surprisingly, the number one complaint is not noise or the sight of the turbines during the day, it's the flashing red lights. Even with a wind lease, people don't like looking out and seeing hundreds of flashing red lights. And I tried to pick pictures of what it might look like here from across Kevon Bay. They're synchronized, they all flash at the same time, generally. And I stood on a porch in Caseville and could see the lights in Ubley at 38 miles away on only 390-foot tall turbines. By placing them on top of a ridge line here, you're going to see flashing red lights over a whole part of the region. Now there is a technology that exists that's called radar-activated FAA lighting detectors, and they leave the lights off until a plane is detected. I know of none of them being voluntarily installed in Michigan at this point. I'm not sure if they consider it, but I tell you that the red lights are one of the things that even the leaseholders really object to. Curiously, even when the turbines aren't turning, the noise is also an issue because you have pitch and yaw motors, hydraulic pumps, mechanical sounds, and what my friend said in the house there that you saw that they moved out of, they said all we heard outside from now on was an industrial noisescape because we're surrounded by all these turbines and they're always doing something even when the wind isn't turning them. And so they hear a constant, some type of industrial noise that wasn't there before. Not saying it kept them up, not saying it made them sick, but it's what they heard outside as opposed to birds and cats and children. So again, back to land use policy. So if you're a zoning official, a planning official, a township official, where do you get your guidance on what you can do with respect to regulating land use? Well, it's called the Michigan Zoning Enabling Act. And so the Michigan Zoning Enabling Act is what gives the townships the power to regulate land use. And it says, a zoning ordinance shall be based upon a plan designed to promote the public health, safety, and welfare. I say it another way. If a proposed development of any type can't protect health, safety, and welfare, it should not be permitted. Developers' recommendations are designed not necessarily to protect your health and safety and welfare, but to maximize their return on investment. And I don't care if you're building windmills or strip malls or housing developments or whatever. Your goal is to convince the planning authority to give you regulations lax enough so that you get maximum return on your investment. But as a sworn official, you swore an oath to protect health, safety, and welfare. So what are your limits to zoning? How far can you go? If you were like me, we never zoned anything more controversial than the ethanol plant that ended up a half mile from my house. But that was it. In most townships, we don't see much change. So what are your limits? Well, in the courts, your limits are that your regulations have to have a rational relationship to protecting health, safety, and welfare. They can't be arbitrary or capricious. In other words, you can't say Catholics are allowed to have 4-story tall houses, but Presbyterians can only have 2-story tall houses. That would be arbitrary, capricious, and a gross violation of their civil rights. But if you have a reasonable regulation that's designed to protect health, safety, and welfare, those regulations are virtually unassailable in court. It's also important to understand that your township board and your planning commission is not obligated to be experts on acoustics, on engineering, or all manner of things, and they don't even have to be right on those things, because it turns out the standard of evidence that the courts look at for your finding of fact to determine each regulation is that was there more than a scintilla of evidence to suggest that that finding of fact was true, but it doesn't even have to be a preponderance. That's the range. More than a scintilla, less than a preponderance. That's your legal standard in court for the underpinning purpose for your regulations. That's it. And so, for instance, when my friends the Schindeldeckers sued the county over what they thought was an irresponsible wind ordinance, they brought in acoustic engineers that said, look, the noise limits you're proposing here are inadequate to protect health, safety, and welfare. And he sued the county. The county won because the judge said, essentially, look, I'm not saying that you're wrong, Mr. Schindeldecker, on the numbers you prefer, but the standard is more than a scintilla, less than a preponderance. And what the county relied upon as their supporting documents to explain why they thought that noise limit was healthful, was an email from Consumers Energy that says, "We believe this project as designed will be safe." That was enough in court. So on either side, trying to sue a community over zoning regulations you don't agree with is pretty much an exercise in futility. So be aware of that. Rational relationship to protecting health, safety, and welfare, not arbitrary or capricious. Something else to consider is the Zoning Enabling Act permits us to regulate things on raw appearance, just aesthetics. I stopped in Gaylord on the way up, and in Gaylord, what do all the buildings look like? They all have this cheesy kind of alpine theme, even the Lowe's store and the Walmart, right, and the McDonald's. Is that because buildings without an alpine theme somehow make people sick or compromise their safety? No, they just decided that that's what they wanted their buildings to look like. They did the same thing in Frankenmuth. You get to regulate these things in your community on the basis of raw appearance. So keep that in mind. That's one of your other options. So, a couple basic questions. Are any developer's profits more important than health, safety, and welfare? Are promised increases in tax revenue more important than health, safety, and welfare? Are claims of private property rights, which I happen to be a big fan of, but nonetheless, are they more important than health, safety, and welfare? Are claims of green jobs or emissions reductions more important than health, safety, and welfare? Under the Michigan Zoning Enabling Act, the answer is no. And remember, it is the health, safety, and welfare that officials have to protect, not the health, safety, or welfare. Too often, health and safety are diminished in exchange for developers' promises of jobs or tax revenue welfare, but those tax dollars, those promises of money are not binding contracts. So, now let's get down to the regulations proper. We could talk about all kinds of things that people want to regulate with respect to wind, and we could be here for 10 hours. The most common regulations are height, physical setbacks, and noise limits. Others may include aviation impacts, like for airplanes, radio frequency interference, which can be an issue if you have broadcast towers in the area, or environmental impacts to things like birds and bats. I'm going to focus tonight on height or appearance, setbacks, noise, and wildlife protection. You can put my name into YouTube and watch any of my presentations, and we can talk about any other aspect you want. Again, if you hire a competent land use attorney, they're going to help you develop the kind of regulations you want, and you can regulate all manner of things. Wind developers typically ask for regulations that look like this. They want now a 500 to 600 foot height limit, they want a 45 to 55 decibel noise limit in any homes that may be in the area. In general, they don't want any property line noise regulations and trivial or no property line setback regulations. They want 1,000 to 1,320 foot setbacks to homes, 30 hours of shadow flicker. If you don't know what shadow flicker is, go home and have your husband or wife turn the light on and off once every second. And just do it for 20 minutes out of the day. And as long as it's not more than 30 hours a year, you won't break a 30-hour regulation. So, what are your limits with respect to regulating height and appearance? Well, you can regulate the height of structures just because you don't want to see them any taller than a certain height. Like we restrict houses to 2 or 3 stories. I happen to be a residential remodeling contractor. We often have ordinances that don't let a house be taller than 30 feet. Is that because 40-foot tall houses are unsafe? No, you just said, I don't want to see them taller than that. Wind turbines are no different. You may restrict their size for the sake of appearance. You want to know what the lowest height limit is that was ever upheld when it being applied to a wind turbine? It's in a case called Johnachek versus Bay Township. A wind company sued and said that your 30-foot height limit is too short and it's exclusionary and it illegally prohibits us from being able to build wind development. And the judge's answer is, you can build all the 30-foot tall wind turbines you want. That's the lower limit under case law in Michigan. So, consider this. We regulate billboards on appearance. You know, if RES or another company showed up and said, we're going to build 100 50-story tall billboards all along the Michigamme Highlands, advertising, I don't know, come to Lance, it's a great place to live, and we're going to put lights on it and so forth, you'd laugh them out of town. It would never get off the ground. Of course it wouldn't. Well, we already know that billboards have blight. I was in Stark County, North Dakota a few years ago, and I did a similar talk out there, and their zoning ordinance says the purpose of regulating signs in the county is to provide for a visually pleasant environment and minimize potentially unsafe conditions, while also offering opportunities for public and private information and advertising. We know billboards, large structures, can create visual blight. Turns out Detroit Edison's Vice President Steve Rawlings recognizes this too. He says in a podcast in Traverse City, certainly there are some pristine places in Michigan where you don't want to impact the viewshed. You take a situation like Leelanau County or the Old Mission Peninsula here in our region, get where I'm going. Certainly there are areas where it just, while it would be perfect economic sense and perfect placement for utility turbines, we probably don't want them as a region there. Well, I can only presume that Huron County is not pristine, and it will be up to you to decide whether or not Mount Arvon is pristine. Curiously, wealthy regions in Michigan like Leland and Centerville townships in the Leelanau Peninsula have adopted very stringent wind ordinances without fanfare or protest, despite a demographic that claims to heavily support renewable energy. One of the guys who is a wind developer salesman actually lives in Leelanau County. While he was demanding that Huron County preserve very permissive wind energy zoning, he lived comfortably in a community with very restrictive wind energy zoning so that he would never have a turbine next to his house. I think they call that NIMBY. That's the word. That's the word. So, how tall is too tall? Just like any other land use in your zoning book, it's up to you. You don't need any science to tell you that this tall is too tall. How tall did you want to see? Now, let's talk about setbacks. Wind developers will come in and say that this is an industry standard, 1,000 feet, 1,320, 1,500 to a house. Industry standard. Well, this chart came out of a peer-reviewed journal called Wind Energy. So again, not exactly Breitbart or the Koch brothers. Wind Energy Journal. And they collated these various setbacks being used by turbine companies or various nations to homes. 1 mile in France and Germany to homes. Rural Manitoba in 1981, 6,500 feet. I've never read this U.S. National Research Council thing. It's meters and then feet, 2,500 feet. Illinois, 1,500 feet. Riverside County, California, 2 miles. And then Michigan, out of this list, makes it. I didn't put it there, 1,000 feet. What's the industry standard? Let's take a look at operations and safety manuals from a couple major turbine manufacturers. Vestas says in their health and safety instructions, if a runaway operation should occur, the plant must be evacuated immediately by running upwind, and access to the surrounding area in a radius of at least 500 meters must be restricted. That's 1,640 feet. Nordex says the same thing. In case of a fire in the nacelle or on the rotor, parts may fall off the wind turbine. In case of a fire, nobody's permitted with a radius of 1,640 feet. It turns out that those numbers are based on science. This is a turbine that failed in DeKalb, Illinois, and my friends that live there measured a debris field of about 1,500 feet, even though it was only a 390-foot tall turbine. Now, my earlier slide quoted safety and operation manuals from the wind companies, the turbine manufacturers themselves. What they will tell you is those manuals are now outdated, they're old. Well, there's a reason we only refer to the old ones. Wind developers claim that the basic safety information in these manuals is proprietary, and they will not release them to planning commissioners anymore. We feel that a responsible wind ordinance should require the submission of those documents in unredacted form as part of the application process. Huron County, Michigan has a Vestas operations and safety manual in their possession, and they will not let you see it. How on earth can I write an ordinance designed to protect health, safety, and welfare if the safety manual from the turbine manufacturer is proprietary trade secret? I don't know how a 1,500-foot setback, and knowing that that's what it is in the event of a fire, somehow makes those turbines less competitive than somebody else's turbine. It doesn't make sense. I'm reminded of what Bill Bennett said during the Clinton thing. If he has nothing to hide, why is he hiding? If there's nothing to hide in those safety manuals, just turn them over. Require it in your ordinance and they will have no choice. So, this just came out January 23rd, 2018. It's only a week or so ago. Skylight damage when ice flies off the wind turbine at the Mount Wachusett Community College. I don't know of a lot of buildings that have been damaged, but this one was. So, it turns out that there's a peer-reviewed paper called Analysis of Throw Distances of Detached Objects from Horizontal Axis Wind Turbines, and it's published in the Department of Wind Energy, Technical University of Denmark, in a journal called Wind Energy. So, it's very technical. They do a lot of modeling for how far various things could fly off the turbine in the event of a failure. So, I don't need to get into all this, but they say, look, it is found that while at normal operating conditions, so it's not a brake failure overspeed event, pieces of the blade with weights in the range of approximately 7 to 16 tons would be thrown out less than 2,300 feet for the entire range of wind turbines, and turbines operating at the extreme tip speed of 150 meters per second, which would be an overspeed event, may be subject to blade throw of up to 1.2 miles from the turbine. For the ice throw cases, maximum distance is approximately 328 feet, which happens when they're not turning, is what they say, when it's in standstill operation. Up to 2,000 feet are obtained for standstill and normal operating conditions, with ice pieces weighing from 0.4 to 6.5 kilograms. Now here's what they say. The simulations can be useful revision of wind turbine setback standards, especially when combined with risk assessment studies. This is a wind energy journal called Wind Energy. It's peer reviewed, and it says the purpose of this journal is to help you establish safe setback standards. Seems pretty reasonable. So, despite published data like this, wind developers routinely demand turbine setback distances ranging from 1,000 to 1,400 feet from neighboring homes, not property lines, leased or unleased for turbines in the 400 to 500 foot class. If there are turbines in operation in Michigan, I can promise you that the setback distances were less than 1,600 feet from a house, or they don't get built in the Lower Peninsula, because we got a road on every square mile and a house on virtually every square mile, and they run out of ground to back up. They say, we can't build, and I say, it's not my problem. It's your business model requires you to shove a size 12 foot into a size 9 shoe. I just read your peer-reviewed wind energy journal that tells me what the maximum risk is of blade failure. So, I call this demand that they measure the setbacks in ag ground to homes rather than property lines. I call this trespass zoning. By demanding that the setback distances for wind turbines be measured from a home on adjacent properties rather than from the property line, which is typical of all other land use regulations, the wind developer is in essence asking the zoning board to grant them an easement or trespass privileges on unleased property. I coined the phrase for that, trespass zoning. Wind developers object to this idea that it's some kind of easement because they're putting noise and other risks into your environment. But if you sign a wind lease with them, this is a next era lease, they buy from you an effects easement. This says, owner grants to the operator a non-exclusive easement for audio, visual, view, light, flicker, noise, shadow, vibration, air turbulence, wake, electromagnetic, electrical, and radio frequency interference, and other effects attributable to the wind farm or actively loaded on the owner's property, etc., etc., etc. So all these things that they say are just myths that people made up, they're still indemnify themselves against and are buying from that landowner the right to do these things on that property. In ag country, and also true here, the owners typically or often don't even live on that piece of property. It's often a vacant field. So the guy who's being protected from these, or being compensated for these things, often lives in the next township or the county. But the guy who lives next door 100 feet from his property line is actually experiencing all these things in exchange for no consent, no compensation. In the mind of a wind developer, it is only an easement when they purchase the rights to do these things to your home. But when they can talk the zoning board into donating the right to do these things to your property, it is not an easement. That just flies in the face of good land use policy. What's this look like? This is not to scale, but if we understand that the developer is recommending 1,000 to 1,320 feet to a house, and the evacuation zone is 1,640, you'll see that, let's say that turbine had an overspeed event and they're supposed to flee the scene, they have to run past your house. And they've never made it clear as to whether they're supposed to knock on the door and warn you on the way by, but that is the standard approach. And you say, well, let's at least move that setback perimeter to the foundation. Well, that's better. Your home is not in immediate harm's way, but you don't just live in your home. The rest of your farm may have swing sets, or you may want to build a house for your daughter. You may have a lot of other activities going on out there. That area, those future development rights have been surrendered to the guy with the lease, who may even live in another county. I think at bare minimum on ag ground, 1640 to a property line is just and reasonable and fair. You think, well, you're making these numbers up. This is an actual wind map from an Exelon project in Bridgehampton that in the end did not get built. It's hard to see these circles, but you see the large orange ones, which are here. I think those are 1,320 foot setback circles. The gray parcels in the middle are not leased into the wind project. The green parcels surrounding are. So I zoomed in a little bit. Again, green is leased, is participating in the project. The gray are not. You'll see these small house lots down here. This guy's not leased. This guy's not leased. Here's his house. The circle cuts through his property, yet this farm doesn't appear to have a house on it. And you see the farm in the middle roughly 50% of his property is covered by the setbacks from the turbines. I don't think that's equitable. I don't think it's fair. I think that's an easement that that person should have had a right to negotiate. What about my private property rights? Former Chief Justice Oliver Wendell Holmes said, the right to swing my fist ends where your nose begins. Reasonable. Everybody has a right to do what they want on their own private property until it impinges on somebody else's right to do what they want on theirs. That's standard law. My corollary says if my development project requires me to repeatedly punch you in the nose, I should first get your consent and then compensate you for your broken nose. These are turbines in Gratiot County. The express goal of zoning in the first place is to separate conflicting uses of land going all the way back to the Euclid decision 100 years ago. I say by establishing setbacks and noise limits from neighboring homes rather than property lines, the conflicting use is actually granted legal access to the neighboring property without consent or compensation. This is fundamentally unjust. Now, people say, well, this whole idea of your head of consent and compensation is some artifice that you created out of thin air. Well, New York Supreme Court judge agreed with us. I wasn't involved in the case, and by the way, the New York Supreme Court is a lower court. It's not the ultimate Supreme Court like it would be here in the state, just to be honest about that. But listen to what the judge says. Though the applicant has stated that the 1,750-foot setback exceeded the industry standard, such setback has impacted upon the use or prospective use of adjacent properties or non-participating landowners without their consent. These setbacks are in reality set-offs, meaning rather than measuring from the property line to the device, you've measured from the device across a private property line, which he calls a set-off of 1,750 feet. The property then of the non-participating landowner is in effect taken by this governmental action without compensation or consideration. The non-participating landowner's property is therefore adversely impacted by the location of the wind turbines as development of a use other than agriculture is curtailed. That's all I've been saying since 2010. So what is the right setback distance for your community? Well, I would say at bare minimum, 1640 for a 500-foot class to a private property line would be reasonable for 500-foot tall turbines. And in view of the recent peer-reviewed research from the wind industry, showing that blade and ice throw is a substantial problem and could have extreme risk to neighbors, far bigger property line setbacks may be reasonable as well. It's up to you. And this is a little more esoteric question, but if you're using distance to serve as a proxy for noise regulation, in other words, you don't want to set a noise limit, you just want to set a distance setback and not regulate noise, and there's some good reasons to consider that because nothing is uglier than getting a legal battle between two acousticians who are trying to determine how much noise is coming from a turbine that only operates at full power occasionally, yet is charging many $1,000s a day to come and try and catch it at the time that's behaving badly. You see, it's very complicated to measure and test and litigate those things in court. Whereas if you just use a large setback distance to serve as a proxy for the noise limits, anybody can measure a mile and a quarter if you're serious enough. You don't need an expert. In Baraga Township, I won't go into this because you're not primarily ag here, but what we did is we used big setbacks to non-participating property lines, to unleased property lines, very small setbacks to leased homes. So if you invited the project into your property, we gave you a small setback and a big setback to unleased property lines, and if the wind company wanted to proceed, they would negotiate easements with all those surrounding properties. That restores to everybody their right to negotiate the value of their loss of amenity by becoming a turbine neighbor. We thought that was fair. If it's not at the property line, you're essentially awarding an uncompensated nuisance or safety easement to the developer at non-participant's expense. And this is perhaps my favorite statement of the whole thing. Equitable wind energy zoning should not forcibly donate unleased property to the neighboring landowner's tenant. It's not even to your neighbor. It's to the guy who rented their ground with a 60-year wind lease. I don't understand why they would have rights to do that to my property. I already addressed that. So, how about turbine noise? How loud is too loud, and who should you believe? Well, some of you are familiar with the Garden Township project down in Big Bay, Denok. 14 turbines. Here's 73 residents in the Garden community who signed this petition demanding relief from the noise. Folks there can hear the wind turbines operating over their televisions inside their house at 1,400 feet. The wind companies will tell you, well, the normal conversational speech range is you're in the 40 to 50 decibel range. That's not a big deal outside your bedroom window at night. What they don't tell you is in a quiet rural community like this, I bet you if you go up on Mount Arvon when the wind's not blowing, you're going to be 20 decibels. And you'll think, well, but when the wind's blowing, I'll hear wind noise, and that will mask the turbine noise. The problem is, if you're sitting in a cabin or in a protected area, the wind noise isn't getting to your ears. There are also times of wind shear where the winds on the surface aren't blowing, yet the turbines are operating at near full power. So the local masking effect doesn't always happen. But the bottom line is, you have very quiet places out here now in a way that we don't even have down below. But the World Health Organization has issued a paper back in 2009 looking at nighttime noise guidelines to protect human health. I don't spend a lot of time talking about wind turbine syndrome. You'll find that on the internet. Wind companies laugh at it. They think it's ridiculous. I know people that suffer from turbine noise. I can't explain to you why, but I know a guy in Upper Michigan who built a bunker in his garage out of blocks, and they sleep in there when the wind blows out of the southeast. Maybe he's crazy, but he's done it for years. It's up for you to decide. But the World Health Organization took a look at what kind of noise levels are necessary in any setting to protect human health. And they said, look, in the 30 to 40 decibel range, the effects are going to be pretty modest. The noise might occasionally wake you up. This is a long-term average outside at night. Populations and chronically ill may suffer some more, but it's pretty small. But they said, look, you get a long-term nighttime average outside at night between 40 and 55 decibels. You see a sharp increase in adverse health effects. Exposed populations have to adapt coping mechanisms like bunkers or white noise machines or earplugs or sleeping pills. And I know people have done all of that in Michigan. And vulnerable groups are severely affected. And above 55 decibels, adverse health effects occur frequently. High percentage of population is highly annoyed, and limited evidence suggests that human cardiovascular system is stressed. Okay, I don't want to talk about wind turbines making people sick directly, but I can tell you wind turbines make noise, and the WHO says noise at these levels affects human health. You can do your own math on it. George Hessler did a paper for the state of Minnesota. Hessler's and his son work for the wind industry fairly regularly. He recommended the state of Minnesota that you keep noise levels lower than 40 decibels. And even then, they said some people would still have issues, but in general, below 40 reduces most of the complaints in ag land, where there's other community noise sources. This one's my favorite. If you go to NextEra Canada's website, under the frequently asked questions section, they say, do wind turbines make noise? They say, well, it's possible to stand under a turbine and hear nothing. Well, certainly it's possible to hear nothing, particularly if it's off. And they said, and at a distance, they're often impossible to hear. That's also true, but what is the distance? But they went farther. They said that the Ontario Ministry of Environment sound guidelines for rural areas establish a maximum permissible sound levels at residences of 40 decibels, and they went a step farther, which is consistent with the standards set by the US EPA. NextEra asked for 55 decibel noise limits outside your house in Tuscola County, even as they tell Ontario people that 40 decibels is the right number, according to the US EPA. Why aren't they quoting the US EPA to Huron County when they're proposing lowering the noise limit to 40 decibels? Some friends did some door-to-door research in the thumb and started talking to people with various amounts of complaints, and then got on Google Earth to see how close they were to turbines. The red lines are people who are unhappy with the noise, the green lines, not so much. The 40 decibel line is right here. You get to somewhere between 2,000 and a half mile away, and most of the complaints for homes drop pretty remarkably, but even then you get some with complaints out over 3,000 feet from wind turbine noise. So, well, that's an acceptable loss, except nobody was complaining about wind turbine noise in that township until the turbines were built, right? So what Raga did was something similar to the setbacks. We used a low nighttime noise limit for property lines of non-participants and a much higher limit for participating homes who signed a lease. They were both waivable to get more permissive limits. We thought it was a compromise. We also added something that's a little harder to understand, but a DVC opens up the low frequency noise that we don't measure at our ears, and we put in a 55 DVC noise limit that picked up the low frequency noise that isn't normally measured. We thought it was a reasonable compromise. So, what about in your community? Well, in view of the non-trivial number of people who have camps within the 1 to 3 mile turbine noise radius, and considering that those camps are desirable precisely due to their remoteness and isolation from urban and industrial noise, even lower noise limits for forested areas may certainly be defensible. That's up to you. I mean, there's a reason people want to put a camp up in Baraga. It's because it's quiet, and it's not Detroit, and it's not Green Bay. And I don't know of any reason that you're compelled to industrialize your pristine wilderness. Now, what about impacts of noise upon wildlife? Well, there's not a lot of research out there, but this literature did kind of a review of other articles on this. And they said the costs of chronic noise exposure for terrestrial organisms. And their conclusion is, look, chronic noise exposure is widespread. Taken individually, many of the papers cited here offer suggestive but inconclusive evidence that natural ecosystem noise masking is substantially altering many ecosystems. Taken collectively, the preponderance of evidence argues for immediate action to manage noise in protected natural areas. The point is, if you have artificial noise overwhelming natural noises, you're going to miss mating signals, predator signals, all manner of things that help preserve certain species. And you have a lot of natural areas now that aren't subject to those industrial noises that couldn't have some effect. I can't tell you it's profound, but I can tell you these people will conclude it's worth protecting. You are free to protect your rural regions in any way you see fit, as long as there's a rational relationship to protecting health, safety, and welfare. You could put low noise limits in, you can limit turbine density, height limits, and large setbacks to property lines, lakes, rivers, Great Lakes shorelines, or landmarks like Mount Kerwood or Mount Arvon. So what about the U.S. Fish and Wildlife Service? Apex's guy told me in Shiawassee County, well, we're regulated by U.S. Fish and Wildlife Service. We have to follow their recommendations. Not so fast. Fish and Wildlife recommends a 3-mile Great Lakes shoreline for utility scale wind development. There still are turbines that were built within that 3-mile setback, particularly over here. Down here, they're right on the edge. But what happens when U.S. Fish and Wildlife says don't build? Well, they sent such a letter to Heritage Sustainable about the Garden Peninsula project, and it says, based on the data currently available, we must once again recommend to you that not construct a commercial wind energy development on the Garden Peninsula because of the high potential for avian mortalities and violations of federal wildlife laws. So U.S. Fish and Wildlife wrote several letters saying don't build in the garden. They built anyways. And now, as we speak, more turbines are being approved for farther down on the peninsula, including near the Fayette State Park. They have no authority, but they can prosecute after the fact. But when the turbines are on private property, like farm ground, how is anybody going to get in to discover that an eagle or a protected species was harmed? But as much as people worry about birds and wind turbine impacts, the bats are the ones that are really at risk here. This is from Scientific American. Bat killings by wind energy turbines continue. They said a research review published in January of this year found that wind turbines are, by far, the largest cause of bat mortality around the world. White nose syndrome, the deadly fungal disease that has decimated bat populations throughout the northeastern U.S., came in second. Biologist Chris Hine of the nonprofit group Bat Conservation International says that if the current industry practices continue and wind turbine installation grows, bat populations already weakened by the fungus will crash. Well, you're in the northern range of the threatened northern long-eared bat. So, what if a wind developer does a measurement of, tries to look for these species in your community? They did that in mind because we're the northern range of the Indiana bat, which is not just threatened but endangered. They went to a woodlot in a farm field and set up one of their large mist nests, which catches them for 24 hours, took it down and said there are no bats, no Indiana bats, 24-hour sample. Unfortunately for them, Dr. Alan Kurta, who is one of the Midwest leading bat biologists from Eastern Michigan University, he said, I hope that the developers act in a responsible way. But when they said we didn't find any bats, he sent a short email that says, then ask them, what the hell did I just study in Ogden Township for the last 4 years if there are no Indiana bats there? It's up to you. Bats may be protected by local township zoning regulations. Again, you can regulate location, density. It's also possible to place restrictions on cut-in speeds and hours of operation and seasons of operation for wind in order to protect things like bats. Remember, Fish and Wildlife does not exercise enforcement authority over the location and operation of wind turbines. Local zoning is often the only means that you have to protect local wild resources. Again, talk to a good attorney about this. So, wind developers, if they're on their game, will claim that your regulations are something they call exclusionary zoning. Exclusionary zoning is an illegal practice whereby you make certain land uses impossible to build under their economic demands. So what the zoning guidebook says is no lawful land use can be excluded when there is a demonstrated need for that use within the locality or region, unless there's no appropriate location in the area to provide for the use. So actually there's a multi-step test for whether or not an ordinance is exclusionary and therefore illegal. The first one, it has to effectively ban the use. 2, this is critical, there's a demonstrated need in your community for that use. And 3, the use is appropriate for the location. And 4th, the use is lawful. If you're having illegal land use activity, you can't claim exclusionary zoning. So guess what? NextEra Energy sued Almer Township and claimed that their interpretation of their wind ordinance was so rigorous that it would amount to illegal exclusionary zoning. It went to federal court. Part of it is still ongoing. But the judge issued a ruling on part of that complaint, and he says, look, wind turbines produce energy, which is of course needed by the Almer Township community. But NextEra's Tuscola wind project cannot reasonably argue that the township will have inadequate access to energy absent the wind energy project. What his point is that there was no demonstrated need for new electricity in Almer Township because the lights already worked. So NextEra's claims were dismissed. There's no demonstrated need. I would argue that it's probably legal. I wouldn't do it yet, but it's probably legal to just issue an outright ban if you wanted to, as long as the lights come on. I mean, that was Judge Ludington's reasoning there. He also said that their complaint about a 2,750-foot setback due to their noise limits is not exclusionary because the wind company can build smaller turbines, fewer turbines, quieter turbines, or buy more parcels of property into the project, which maybe they don't want to do, but that doesn't make it exclusionary. So don't be deceived. If somebody tells you that they have an exclusionary, that you have an exclusionary wind ordinance, I would say just laugh at that statement, honestly. They may sometimes refer to the 2007 or 8 State of Michigan wind turbine siting guidelines as still being in effect. Detroit Edison continues to do this, even though those guidelines were never binding. That Governor Snyder abandoned those guidelines, and the current state policy says there is no one-size-fits-all approach to wind turbine siting. It's up to y'all. And in the latest energy bill, the one thing that I like is we got this amendment added that says nothing in this new energy package, which raises our renewable energy mandate, takes away the township's right to regulate wind as they see fit. So you're still protected. By the way, many Michigan counties and townships have adopted regulations that protect their residents from irresponsible wind energy development. And they often claim that it's exclusionary zoning and they're going to sue you. They flew attorneys in from Colorado Springs into my township, Farmington Hills, Grand Rapids, all lined up and said, if you pass this ordinance, we're going to sue you for exclusionary zoning. They passed it anyways. The people put it on the ballot. The people supported the strong zoning, 64 to 36%. The leases got canceled and the lawyers went home. That's all that happened. Threats of litigation are common. Actual litigation is rare. Retain a good land use attorney and they will put you in a strong position. So wrapping it up, I know you've been here a long time, but usually I talk way too fast and nobody knows what I'm saying. Most land use changes are pretty benign. I know people will argue about whether or not your signs in front of a commercial building could be 25 square feet or 30 square feet. All right, you can make a case for each side, but honestly in the end it doesn't make that big of a difference, right? But wind turbines are not like that. And we felt that due to their size, the impacts are disproportionately large, and we felt that the ordinance should be written in such a way that the surrounding neighbors have to give their consent and be compensated for their loss of amenity in order for the project to go forward, that we would not grant these guys free easements. On ag land, we like the 2-stage setbacks. On forest ground, you may need much larger setbacks and lower noise limits in order to protect scenic areas. And honestly, you are probably perfectly justified in just drawing circles around your most precious scenic areas and say, we choose not to have wind development there. Why? Because it's frickin' Mount Arvon, that's why. What more do you need to know? Sorry, I'm trying to be unbiased, but I'm thinking, you're gonna put one on Mount Rushmore? Remember, nobody has ever come into your local planning commission and said, the light coming through my windows is too steady, could you make it flicker once a second for 20 minutes a day? The noise level at camp is too quiet, could you raise it to 40, 50, 60 decibels from 20 or 25? My property values are too stable, could you build some 50-story industrial machines next door that put that property value at risk? The rule of zoning is this: you were here first, you get to decide. Only 2 types of wind ordinances. Wind developers want ones that grant them these easements across unleased property. I think reasonable wind energy zoning demands that those easements be negotiated individually and privately between the developer and the impacted landowners rather than forced upon them by zoning regulation. You can make that happen by having large setbacks to unleased property lines. I've already said that. So, what's your next step if you're a township official? What if you think the recommendations I make more sense than maybe what the wind guys are telling you? What's your best course of action? Well, if you have township zoning, and I think most of the townships in this area do, the places where most wind has been built in the state, by the way, are unzoned townships under county zoning, because the county commissioners don't care in general about only a few townships. They typically only have one commissioner out of 7 or 9 or 5 that are worried about their interests, and they see the tax revenue. So they write permissive zoning, and only a couple townships get the turbines. That's what happened in Gratiot, that's what happened in Huron County. Here it's harder for wind because you have local control of the zoning. So, if you're concerned and you want to take your time to think about it, you have the right under the common law of the United States to adopt a moratorium for 6 months, a year, year and a half, and you can revisit your zoning ordinance at your leisure, and during that time, no permits for wind energy development can be submitted or acted upon. That's reasonable, I would recommend it. Put a moratorium in place, take a time out, and think about what you want to do. You are fully within your rights to do that. Is it too late? We often hear township officials say the wind company has already signed leases. We cannot stop them now, they have a contract. If I sign a contract with a private property owner along 41 to put a strip of adult bookstores in there, does that obligate your township to permit adult bookstores to go along 41? No. A private contract between private parties doesn't obligate a township board to do anything because you're the government. Your township board is the government. They have to beg you and ask you for the zoning changes you need. They cannot demand them, and a private contract doesn't obligate you to act in their favor. When is it too late? When does a company, any developer, have the vested interest in your zoning ordinance and the regulations that are there? The case law is clear. 2 things have to have been satisfied. They have to have been issued a building permit to build a building or a commercial structure or whatever, and they actually have to have commenced construction. Substantial exterior construction, even moving walls inside the building under that permit is not enough you have to start digging on the outside. Case law has shown even up to that point, before you start digging outside, the township can change their zoning and you're screwed. The case law is clear. So until a permit has been issued, until they've actually started digging holes in the ground, they're not grandfathered into your ordinance. So again, my talk is based upon the Baraga Township Wind Ordinance, which is available here at this website. And this is when I stop to take questions and drink my pop. If you have questions, just raise your hand and I would respond. Well, do you have some written out?
Yeah, we have 4.
Okay.
These 2 are.
Okay. Oh, what kind of subsidies does wind energy development get? Well, first of all, they will argue with you that it's not a subsidy, it's a tax credit. Well, I say a $5 billion tax credit takes $5 billion of lost revenue from the U.S. Treasury that could be used for veterans benefits, Head Start, et cetera, et cetera. That's much different than a subsidy, which takes $5 billion out of the federal government, no longer available for Head Start, veterans benefits, et cetera. So that's, I tell you, they make this stupid argument that we don't get any subsidies, it's a tax credit. Well, the tax credits are ratcheting down. It's still possible, depending on how they've gerrymandered this system, to hang on to the bulk of the production tax credit right now with certain safe harbor contracts. I don't know what this local developer has done in that fashion. How much is the tax credit worth? Detroit Edison told the Public Service Commission that the Meade Township Wind Project would come in at about $48 to $50 a megawatt hour with the production tax credit, and without the production tax credit, it would come in at $80 a megawatt hour. I actually think that's too big of a change, but that's what they told the Public Service Commission. They valued at $30 a megawatt over 20 years. The wholesale value of electricity in MISO in certainly 2016 is only $25 a megawatt hour. So the subsidy or the tax credit that they receive, assuming Detroit Edison's math is right, is roughly equivalent to the wholesale value of the commodity they sell. It's very high. And how valuable is it to the wind industry? Historically, whenever the production tax credit is phased out, wind development has collapsed. And they're not trying, and they wait for it to come back. Who pays for the power line? Well, that's a good question. It depends on how they put the thing together, but sometimes wind developers are able to convince the transmission authority that the power line is a multi-value project and not just a dedicated wind transmission line. Don't want to go too far afield in this because I don't know all the ins and outs of it, but to the degree that they're able to convince MISO or the transmission authority that it might be a multi-value project, they might actually get to socialize the cost of some of their transmission anyways across all the ratepayers. But I don't know that that's exactly what would happen here. I know wind lines are pretty expensive, and the question is, when does it become transmission? We know that they're collector lines generally until they get to the substation. From the substation out, it's usually considered a transmission line. You know, I don't want to dig into it too deeply, but what do they do with the blades that are not usable? We talk about wind being green and sustainable. Each blade weighs typically now somewhere between 11 and 16 tons. They're made of essentially unrecyclable hydrocarbon-based resins, fiberglass, carbon fiber. To my knowledge, nobody's yet developed a way to profitably or effectively recycle them. They are cut up and placed in a landfill, to my knowledge. And in general, those rotor blades last about 10 years and they have to be replaced. I can't say they all fail that quickly, but I know that Exelon had to build, I think, a laydown pad near Minden City and pull a lot of the rotor blades off and x-ray them and look for flaws and reinstall. So anyways, and we've seen a lot of rotor blade replacement and failure in Huron County. Yes, sir.
According to a website that my wife was on in a different part of the country, when they failed, they were burying on site because of the cost of removal.
I don't know. That's possible. I don't know, but I know that it has to be disposed of properly. The thing I didn't address in this talk either is it's a good question. What happens to the turbines when they're no longer serviceable? And what my ordinance does, which I didn't talk about here, is it has a decommissioning requirement. And what we did is we required the applicant, the wind developer, to pay us a fee to retain an independent third-party expert of our own choosing to place a value on what it's going to cost to tear a wind turbine down at the end of its useful life in the event that the wind company that built it or owns it is no longer solvent and capable of doing it on their own. And I think that's a good approach to do it. Force them to pay for a consultant who will tell you what it's going to cost. The reason you want to get your independent third-party consultant is this. A number of years ago, I spoke on wind in Ogemaw County in West Branch, and the wind developer's name, and this is not a joke, his name is Stephen Smiley of Stephen Smiley Enterprises. And he had told the county commission the month before that all you have to do is loosen the bolts, set some dynamite on one side, and they drop like a tree, and you cut them up for scrap. Well, the truth is, you can't really do it that way. I guess they do sometimes get toppled that way, but they got 200 to 400 gallons of oil in them. That has to be handled properly. Typically, they bring a crane in to take care of these things. You can't just responsibly drop them over. And secondly, the steel pieces are so large, you can't just haul them in one section like an old car to the scrapyard. They got to be cut up small enough so that they can be handled and put back into the furnace to be reprocessed into new steel. So it's very expensive. We've seen prices anywhere from $60,000 to $500,000 per turbine to decommission, depending on whether you're taking out a whole installation of them or having to take care of one individual turbine. But I've seen numbers anywhere in that price range. But it's expensive, and you want to be protected. Your township can't afford to take down 30 or 40 of them at your own expense. And the reason it's a problem is these wind projects turn over ownership a lot. The oldest project in Ubley was started by Noble, built by John Deere, now owned by Exelon, and Exelon has started a new company called Continental Wind. And I don't know if that project's going to become part of that or not, but that's only 10 years. So the people you're dealing with today are not going to be the ones you're dealing with most likely at the end of the usable lifespan, unless you're with NextEra, Detroit Edison, who so far seem to own them and never sell them. What service roads will be used to access the project? Will the roads be all season? I don't know, but it's my understanding that they said we're going to use the existing roads, but the idea that a two-track is going to be adequate to haul 180 or 200 foot long rotor blade without serious improvements is naive. In farm country, where we have square roads every mile, they have to build turnarounds across the corners because you can't get the trucks around the corner, et cetera, et cetera. I mean, you're fooling yourself if you think it's going to be virtually unobtrusive. There will be a substantial change to the roads. The stuff is heavy. You got wet ground, you got sandy ground, you got rocky ground, all that stuff, you have to negotiate these huge cranes and stuff through there. It's doable, they know how to do it, but the idea that you're gonna go back to a 2-track afterwards where you used to sit and drink a 6, it's not gonna be the same experience anymore, I'm pretty sure. Or a 5-pack, my brother stops and gets a 5-pack on his way home from work. Yes, sir, in the back.
What's the fire risk per operating hour and how many occurrences are actually documented? These are really great pictures. I don't see a lot of trees. So a fire in a forest, you only need 1 or 2, so do we have any data on that?
There is data on that, I don't have it at my fingertips. I know blade throws are estimated to be 1 per 100 per 1 per 1,000 per year is the range I've seen on blade failures, though a few months in a row they were losing them in Huron County, and Detroit Edison the first time said this is rare. The second time they said, well, it's still rare. Well, all right, I want to say it's rare. Yeah, I mean, look up the Huron Daily Tribune, you can see I'm not making this stuff up. I don't know what the fire risk is. Sometimes it's lightning strikes, sometimes it's equipment failure. I know the most horrific thing I saw was that a turbine caught fire with 2 operators on top in Europe and they burned to death. There was no way for them to get off. But I can't say that's going to happen to the turbines here, but it's a real risk. So, yes, sir.
Yeah, I used to work for the Army in Corpus Christi, Texas. It's mostly flat farmland, and by the time I left Texas for the last time, they literally had a forest of them things. As long as I wasn't looking out over the water, I couldn't look in any direction and not see as far as the eye could see. But you know, I've never seen all of them turning. Sometimes there'd be as little as a third of them turning or a half, but I've never ever seen all of them turn.
One of the reasons there's so much wind development in Texas is developers like to have close and cheap access to transmission because it's expensive. And Texas decided to build, I think, $8 billion worth of wind transmission that I think was spread across all of ERCOT, which is their own private grid operation. And that's why you've seen so much wind there, and it's a pretty strong wind resource. And they also have a high percentage of gas-fired generation in their grid now, which makes it easy to integrate gas or wind. Wind has a sporadic output, and you need a lot of gas generation in place to balance that output. Yes, sir?
I'm guessing that almost all the land where these turbines would be built in the Michigan Islands is CFR land owned by the timber companies, and it's open to hunting, and they get a tax break because it is. Now, is this area still going, would it still be open to hunting? And the company's gonna, I mean, is it risky that you're hunting there? Anyway.
Right, that's a question I can't answer. I never heard about the CFR stuff until I got up here last night, so I'm certainly not an expert on that. I'm certainly going to guess that it's not all that desirable to sit next to a turbine for hunting. That's not usually why people come to Baraga County, but I don't know. Back over here first.
Yeah, so we live up here, I mean, it would be a lot different than where you're at down there, you know, because of all the trees and forests and everything. Up here, our utilities are way higher, I'm sure, than yours down there.
Yes, they are.
And, you know, I don't know what group would be in favor of any kind of energy. What would you say? I mean, if it's not wind, it can't be solar, we don't have enough sun up here. It's not coal, it can't be hydro, people won't put dams. You know, then they go pipeline, okay, if you go pipeline, then they can't go under a river or into a swamp. So what would your recommendation be to try to get some kind of energy up there to lower our costs?
Well, that's the thing. This is a township zoning question, which isn't where the townships aren't obligated to find a solution for our energy needs. So I want to be clear about that. You don't have to be able to answer that question in order to regulate this land use. But as far as there are only so many available options. That's the bottom line. There are only so many available options. But the option you don't have is wind and solar without gas or without coal. So the question is, where are you going to have the gas and or coal or nuclear generation, because you can't get rid of those. And then the question is, what are you going to gain by adding wind and solar to that generation mix? So, but you're right, if you're anti-wind, if you're anti-coal, anti-gas, and anti-nuclear, then you are pro-darkness. Because you have to have one or multiple of those three to keep the lights on. Wind and solar alone will not do it. But people say, what's your solution? If you don't have a solution to this, then you're part of the problem. And my answer is, I don't have to know that I don't have to know what the cure for pancreatic cancer is to know that peanut butter and jelly sandwiches aren't it. You know what I mean? I don't have to have a total solution for an energy package to tell you that these things need to be sited in a way that they don't drive you people crazy. And that's the main point of my talk. If you were to ask me what would I like to see, I'd like a suitcase-sized device like this that I can buy for $25,000, own for my whole life, cut my grid connection off, give real competition to our monopoly utilities, and take that thing with me wherever I live. That's what I'd like. It doesn't exist, but I'd like to have it. So, yes, sir.
Could a zoning regulation be put in that those cannot be built on CFR land and maybe and it cannot have been a CFR land for a certain number of years before they put, would that be reasonable?
Perhaps, but what Lance Township has right now is something that's stronger than that, because my reading of the Lance Township zoning ordinance says that they're not allowed to build these on forestry ground, but only conservation and rec ground. And virtually all the turbines proposed for Lance Township are proposed for forestry ground, which means RES needs a zoning amendment to take place for this project to go forward. And your township does not have to amend that ordinance if they do not want to. Secondly, let's say that the company was successful in getting your township to adopt very permissive wind energy zoning. Would that be the end of it? No. The day that ordinance gets published, you have 7 days to turn in a letter of intent that says we're going to put this issue on the ballot to see if we like this new zoning ordinance amendment. Then you have 30 days from the day that ordinance was published in the paper to gather signatures equal to 15% of the number of the people that voted in the last gubernatorial election in your township, which might be 100 folks. You could probably pass one here and be pretty close to having the numbers you need. Put it on the ballot. And if that ordinance does not survive on the ballot, then you're back to the old ordinance and you have to start over again. So, if you're asking me, we're to have an election like that on a permissive wind energy ordinance in this township, what would the results be? I would say 90 to 10, because southern Michigan townships have, which is a big pile of farmers with pro-wind hats on saying, I've leased my ground, I want my turbines. You don't have that here at all. There will be some folks that want it for environmental reasons, but I tell you, the pro-wind folks have never been a majority since 2009, and there's not a chance in the world they would be in the minority here. So if you want to ask me another question, what do I think the odds are of this project ever being built are? About as close to zero as any township project I've seen since 2009. And let me say that's not because Kevon Martis, the feared anti-wind activist, came here. It's because the Michigan Zoning Enabling Act gives you certain laws that permit you to decide for yourself what you can do here. I can't stop a wind project in this township because I don't vote here. Yes, sir.
So far, we've only talked about zoning in terms of such large-scale structures. What if someone wanted a small turbine that is just or maybe a corporation wanted a small turbine
Sure.
on their property? I think, or somebody on the lakeshore wanted a turbine to take advantage of the wind. I would think any zoning ordinance would have to take into account all of those
Yes.
options too, including some of which might be perfectly reasonable.
I agree, and what the Riga ordinance does is has on-site wind regulations for home scale use and utility scale regulations. I agree with that. Excuse me, I don't have an objection to on-site wind. Neither do I have an objection to utility scale wind, but I think it belongs on industrially zoned properties. That's where I think it belongs, because in my mind it's an industrial use. In Ohio, Whirlpool Corporation and a couple others have built 3 or 4 turbines around their factory perimeters. I don't have a big problem with that. Hopefully they're being good to the surrounding homeowners. I don't have a big objection to that, though I don't think we should be subsidizing them, because that's the only way they generally get built. But nonetheless, I think it's not inappropriate to put industrial uses in an industrial district. My objection is when you want to put it next to homes. Let me go here and then to here.
I think we missed part of what Harry was getting at.
Oh, I'm
with
sorry.
this question. And that is, there's been an implication that if we permit this kind of project in our area, that our cost of energy is gonna go down.
Oh, I doubt it. I can't prove it, but I doubt it. There's a chance it could go up. Wind energy in general is not cheaper than energy from existing sources in most places, but you got this weird scenario here with these new gas generators and the big change that's taking place. It's very difficult to understand exactly how it's going to be impacted.
What I'm getting at is, do we have any assurance that this energy gets sold locally?
No, and most of the time it is not. So it's like the Garden Peninsula project. I think that project's energy was sold to Consumers Energy, but whether it was deliverable to any Consumers Energy customers, I don't know. You know, so it does flow into the grid here, but does it bring you any local benefit? People often ask, well, if I get turbines on my farm, I get free electricity? Heck no, you're not gonna. It doesn't happen, but it's a common question. I don't see a means by where this is gonna lower your rates. Now, if UP Power stands up and tells me I'm wrong, I'm gonna defer to them because they know more about it than I do. But I tell you, the regulators I talked to, including a former MPSC commissioner, he said, I don't see any ways that the imposed costs of wind generation don't drive up the costs on the new generation that's been built. That's my opinion. It's debatable, but I think I'm on pretty solid ground.
Well, we get our energy from REA, most of us do, and REA buys it not necessarily from this windmill project. They would be buying it, I mean, today they're buying it from Green Energy, I think. Who knows?
I will tell you that the co-ops in general, when I testify in Lansing, are one of the few groups that will stand up and side with me on the cost of wind energy stuff. Because first of all, co-ops are a co-op, so they don't pay income tax because they're cooperative. So they don't get a direct benefit from the production tax credit because they already don't have a tax burden. Yes, they could sell them. And in general, a lot of them don't generate much electricity. So having to buy more electricity at a higher cost from wind generators instead of buying it on the wholesale market or from other arrangements is not beneficial to their customers. So Craig Bora, who heads the co-op association, he followed me one time and said 2 or 3 times, as the earlier speaker said, as the earlier speaker said. Same thing, Dan Dashiell, the CEO of Cloverland, he and I shared the podium in Schoolcraft and maybe Delta, and again, he echoed a lot of the things that I was saying. Wind is a high-cost, low-value commodity. It's not just energy. It just offers essentially energy, very little capacity, which is a technical term, not a lot for voltage support, frequency support, inertia, etc. It doesn't offer all the services that a gas or coal or nuclear generator offers to the grid that most of us won't understand because it's complicated energy policy stuff. But energy is high cost, low value. It also shows up at times that are inverse to market demand, which means it's often there when you need it the least and not there when you need it the most. Imagine you run a 24-hour-a-day truck stop and you know there's certain rushes at different times. Which is the employee that's most valuable? The one that shows up when a school bus full of college kids wants to be fed and you can call him down from upstairs and he starts cooking burgers? Or the guy that said, well, the sun was shining today, so Mr. Solar showed up, and then at 2 in the morning when nobody was here, the wind guy showed up and wanted to work. My point is, energy that's available at human command is just worth more than energy that shows up at his own whim, just like an employee. Yes?
I have a question on how many communities in the state have had referendums and how many have passed in a favorable way for wind turbines?
There have been 17 elections, not all referenda, but there have been 7, I'd have to think, but virtually all of them were zoning referenda. And wind has never won one since 2009. 17 out of 17 times the townships have voted them down.
I have one other question. I heard that they used dynamite to put in the test wind up in where the wind things are.
The Met
How
Tower.
far do you have to go down to put something up that's 1,400 feet?
Well, they're not 1,400 feet. That's the distance from the house.
Oh, the distance.
That's the
okay.
distance from the house.
How far do you have to go down?
I can't speak to that with clarity here because most of the turbines constructed down below are on clay and dirt soils. Here, I know you have more rock. I don't know, I mean, I'm a builder. I know there are probably going to be mud mats and stuff, and there are going to be ways it'll be pinned into the bedrock in a way that's not the same down there. But we don't blast where we live because it's clay soil and you can dig down 200 feet and never run out of clay unless you hit limestone. Up here it's going to be different. I can't address that, but blasting is not something we normally see in part of our projects. Yes, sir, over here.
Where are these turbines made and the blades?
Depends company by company, but I know a lot of the parts in all these turbines are from foreign countries. Brazil, Spain, China, the gearboxes are often from China, which is funny because the wind companies in Ohio right now are telling us, give us more permissive statewide zoning regulations so we can free up billions of dollars of investment into your state. Well, yes, the devices cost billions of dollars, but Ohio doesn't make complete turbine assemblies. The parts are imported, And so the money that's going into that project largely leaves the state and even into other countries, because they're foreign companies like Iberdrola from Spain that built their first project. So the billions of dollars of infrastructure, that money left the state. The money that's being paid to the company for the electricity leaves the country, and the only local benefit you're likely to see is some aggregate, sand, gravel for roads, bases, concrete, and some excavation work. So that's the part that you might see some local jobs. It will be during the construction phase. You're not likely to see many long-term jobs, and they'll say 4, 5, 6, 8 full-time employees, but a lot of times the service work, O&M work is performed by specialists who come in from out of the area. And a lot of times the turbines themselves are erected by companies from Minnesota and other places like White Construction. And your local guys with a backhoe are not going to build a turbine. So, yes, sir.
I'm thinking back to your friends who have that, you showed a picture of their house that they had to move out of.
Yeah.
If people in a situation like that, can they argue that the assessed value of their property should be lowered because of the issue of this turbine close by?
Some places have reduced the assessments because of turbine proximity. Wind guys will bring you articles that appear to suggest that house values have risen because of proximity to turbines. I don't think, look, the wind companies will bring you a paper by Ben Hone called Hedonic Analysis of Property Values from Wind Turbines. They'll say, it says there's no statistically significant loss of property values associated with having turbines near your home. First of all, I say, do I need a government study to look at that and say, would I pay more or less for it, right? Do I really need a study to tell me that your market's going to be cut at least in half? Because not everybody wants to live this way. On the other hand, there's 11 studies that show substantial loss of property values. Whether the local taxing authority will give you a break depends, but the London School of Economics, again, not exactly the Koch brothers or Breitbart, studied wind turbine development in England and saw on average an 11% drop in property value. So some districts are reducing valuations, others are claiming it doesn't harm anything. It almost becomes more political than based on real assessment. So I can't give you a flat across the board answer. Anybody else? Yes, sir?
Yeah, we saw that they're planning one on Arvon and Perwood. What's your thoughts about if it was limited as to how high of an area you could build on?
Well, it's something you're free to do. I will tell you, if you don't permit them to build something at least 450 to 480 in height, they're not going to build. But it is reasonable to apply height limits. There's a lot of ordinances with 199-foot height limit. It's up to you.
But I wouldn't think they want to build in the valley.
No, they don't want to build in the
What
valley.
I'm saying is, so far, you can't build so far above the sea level, let's say.
Yeah, you can regulate a lot of those things. Remember, in the end, there's only two kinds of ordinances. One that lets them get built, and that will be on the wind company's terms. It's not going to be more than a certain number of feet from property lines, or they won't be able to build, and it's not going to be with a noise level below a certain number. So if you want turbines, you just ask RES, what do you want in the ordinance, and you say, okay. That's easy. And it's going to be in the same range that any other developer asks for, because it's based on their economic opportunities. But you are free to do anything you wish, as long as it's reasonable, to regulate those in location. You don't have to rezone your forestry ground to permit this. You've got strong arguments. You can even argue tribal rights. You can argue all kinds of reasons for why it's not a suitable place for wind. But it's up to you. You live here. I don't. But I'm not coming back if you let them in. Yes, sir.
At times, it seems like building regulations connect to some degree to firefighting capability. So sometimes communities only allow homes or buildings to be of a certain height because they don't have the ladder trucks to service
That's
other
right.
buildings. And I would think that these turbines would bring kind of a unique problem, particularly in a forested area like that, for firefighters.
Yes.
Whether you're concerned about the employees or people around there or forest fires. So that would be another thing I think that would
Well, the protocol.
place some kind of a burden, financial burden on the community to see that that type of service is available for fire suppression.
Well, the protocol for battling a turbine fire in a nacelle is to stand back and watch it burn. They're not fought, because you can't. Curiously, tall structures like skyscrapers require built-in fire suppression. And you're right, houses can be closer and closer to each other under the building code, depending on what kind of materials the walls are made out of. And you can go up even to 0 lot line setbacks if you have non-combustible materials building your walls. So you can certainly require onboard fire suppression for wind turbines. They won't build if you require it, but it's not unreasonable. We would require that in other tall structures, and not just a tall structure, but a structure with a confined space where human beings go up there and work and so forth. I mean, so you can require that, but every time I've seen anybody ask for onboard fire suppression, the companies have said, no, we're not interested in doing that. But yes, you can put all kinds of limits on it. Yes, sir.
On the bottom line, this is basically an undesirable area for a wind company to put up those structures. Why are they doing it? Or are they proposing it?
I won't speak for that. Everybody has a different economic model as to why they want to do certain things in certain places, and I can't read their mind as to why they find this desirable. I've already hinted that I think some of the reasons are that it's difficult to build in other parts of the state. I think because maybe some transmission changes that may have been made for the gas plant, it makes it more desirable to reach over this way now. I can't answer all that stuff, but economically, I don't know why. RES intends to sell the project and not own it for long term. So that will change their economic model in a way that DTE, who wants to own it for 20 years, maybe wouldn't look at it the same way. So I just don't know. I can't begin to read all the developers' minds. Yes, sir, here.
Just curious, how much is the lease, what's the farmer collecting for one of those?
It depends. It varies by the terms of the contract. Typical range is somewhere between $6,000 and $12,000 per year. Depends on whether or not you're getting royalties from the energy, if you got a guaranteed minimum, but everybody negotiates them in a different way and has different terms, but that's a common range in that range. Next, sir, back. Yes.
The energy that's produced, isn't it true that there has to be a backup energy? I mean, you addressed that a little bit. Where does that come from, the backup energy, when the wind doesn't blow on these?
Well, it's not quite backup, because sometimes people will think that every time you build a wind turbine, then you have to build a gas-fired backup plant. That's not true. But flexible generation does have to exist on the grid somewhere, and firm supply, because wind turbines don't generate firm supply. So in general, the way I think of wind development or wind turbines is like this. In a competitive environment, if you have two species competing with each other, the stronger one kills the other one, and the stronger one survives. So if natural gas turns out to be cheaper than nuclear and remain that way, it will destroy nuclear will go away, and gas will replace it completely, which it can do because they're interchangeable. A gas generator will do largely the same things that a nuclear generator will do in completeness. Wind is a parasite-host relationship. Wind attaches itself to a fossil fuel plant. This is how it works according to the grid. It attaches itself to a fossil fuel plant, steals units of energy sale from it whenever it runs, but at a cost higher than the fuel savings, and it increases their O&M, yet it can't kill off the host, because if it kills off the host, the parasite dies too, because you can't keep the lights on without the host. So that's really how it works. It's a parasitic-host relationship. And so the idea that I'd rather have wind than coal, or rather have wind than gas, is misinformed. All wind is an expensive, fuel-saving attachment for existing gas or coal power plants. And the price of wind energy is $60, $70, $80 a megawatt hour without subsidies. And the value of the fuel it saves in coal is about $25 a megawatt hour. In gas, it's about $35. There's no economic benefit by replacing fuel with wind energy that costs far more. Yes, sir.
My name is Mason Sorensen. I work for RES. And I just wanted to let people know that I was here. I'm here to listen. I came here tonight to hear some of the community's concerns. We will be back in a lot, but we'll be back on February 21st. We're having an open house in this room. And we're hoping that you all come back and hear another side of the story. Not quite as evil as Mr. Martis has suggested.
I don't think you're evil.
So I just would like to ask that everyone have an open mind, and we're going to be back here in a few weeks presenting a different side of the story. And I encourage you all to do your own independent research. And again, mainly just keep an open mind. Not everything you heard tonight is completely accurate.
It's pretty close.
It's good to get different sides of the story, and I would just encourage you all to do that. And here's a flyer I'll leave at the door for our meeting in a few weeks. And but we appreciate everyone learning and what they think about it.
All right, thank you. Now, we've been here a long time. And I will take one more question. I will also stay up here to answer your questions for as long as you like. But I will take one more from the floor, because I know folks want to go, and we got to go back to Marquette yet. Yes, sir.
Okay, this question asked is why here? I know deep down inside that a company like Lundin Mining that would give $100 million to the Clinton Foundation to cover up human rights violations at their mine in Zaire, which she did, would also be willing to put a little bit of money on the plate for a company to penetrate a system that would keep them out, if possible, from developing an even larger mining district. When they started that project, the nickel alone was worth $8,000 a ton. The last time I saw it posted on TV, it was $23,852 a ton. It had tripled. That's just one thing. But anyone that, and so I wouldn't put it above them, giving them an extra inducement to come here.
Okay,
Just
well,
one thing.
but I need a question,
one
sir.
thing,
Could you
I
just
just
ask the
want to say
question,
one
please?
thing. Anybody that would come in and damage what we have in our environment and the beauty of our landscape with what they want to do is evil. I have no doubt about it.